Welcome to the Distressed Business Playbook.
Welcome to the Distressed Business Playbook with attorney Todd Duffy, founder of Todd E. Duffy PLLC. Todd is a New York bankruptcy attorney who works with businesses and decision makers navigating financial pressure, restructuring, and complex legal challenges. I'm Evan Mack, and today we're talking about what actually happens when a business files Chapter 11. Todd, welcome back, brother.
Thanks, sir, and thank you for having me back.
Good stuff. So, Todd, what is a Chapter 11 case really meant to accomplish for a business under financial pressure?
So you could do a number of things under Chapter 11. You can liquidate, you can restructure, and by restructure, it means that you are looking to pay your debts over time and maybe not pay them all off at 100%, but pay them at some portion. And depending on the type of creditor, you're going to want to satisfy the owed debt by paying that portion. The main thing about it is we talked about last time, which was the automatic stay. And so that applies in every scenario in a Chapter 11.
So what changes for a company almost immediately after that Chapter 11 filing?
The interesting thing about this, well, you may not think it's interesting, but but this is what, but I think it's interesting. The interesting thing about it is not so much. The debtor becomes what's known as a debtor in possession. And so they operate their businesses just like they would. There's a lot more scrutiny, which means that there is an office of the United States trustee, which is part of the executive branch of the government. And they are overseeing the Chapter 11 bankruptcy. And they want to make sure that every transaction is ordinary course and things that they would normally do in bankruptcy in business. And then if they're outside the ordinary course of business, the transfer or transactions that they have to do, then they're going to want to give make a motion in front of the judge and in the court and make sure that the court approves of it.
So, Todd, how much control does a business typically keep over its operation once the case is underway?
Usually they have full control over the business. And again, as long as the business is operating the same way that it always did, then it's not going to be any kind of problem. If the business is operating outside of the ordinary course to do anything, then they're going to want to get court permission in order to do that. So that could be something, for example, like selling the business or selling assets in the business. Normally, businesses don't do that when they're operating, but if you wanted to do that, you could still do it with court approval.
Where does court involvement become most visible in a Chapter 11 case?
The court is involved in most every aspect of a Chapter 11 case, but it mostly becomes when there are disagreements between the parties. Bankruptcy is sort of an odd form of litigation because most of it takes place outside of the courtroom, negotiations, settlement, that kind of thing. But if you can't come to a resolution outside the courtroom, then the judge gets involved and the parties air their grievances in front of the judge, and the judge decides based on the law. And the bankruptcy judges are really smart, and they understand the code and they understand what's at stake, and they usually come to their decisions from the bench, so it's fairly quick.
How do negotiations with creditors start to shape what happens after a filing? Depending
on the size of the case, it actually is a big factor in whether or not you're going to be successful or not successful in a Chapter 11 case. And success is really measured by what the client's goals are. If it's just to buy them time, to see if they can restructure and pay their creditors over time, negotiations are everything. And, keeping good relationships with counsel or with the actual creditors, that can make or break an entire case. And, that's really something that I've been taught over a long period of time.
So can you walk us through a situation where a Chapter 11 filing changed the direction of a struggling business?
A long time ago, I guess this is back in 2006, I represented a very small record company and a recording company. Wasn't a record company, they were a recording company, and they had new artists and everything else. And they were, moving right along, but suddenly things stopped. And they needed some help. They had tax issues. They needed some help with kind of paying their bill, basically what I was describing before, paying their bills over time. And so they managed their business after we filed. And their biggest creditor, as I recall, was a taxing authority from Massachusetts. And while the case was pending, I picked up the phone and I called the taxing authority. And I asked them if they would be able to resolve this and compromise this. And they said yes. And because they said yes, and one of the equity holders was willing to reinvest in the company so it could emerge from 11, they were able to have a plan confirmed, and they were able to actually move their business forward.
What parts of Chapter 11 tend to catch business owners off guard once they're inside the case, Todd?
Business owners are very much entitled to do basically whatever they want when they're outside of bankruptcy. So if they want to do something that's not really what they normally do, that's fine. But and they only have to report, especially large businesses, only have to report to shareholders on an incremental basis, usually once a quarter or something to that effect. In bankruptcy, you have to report all of your transactions, whether inside the ordinary course or outside the ordinary course, every single month. And you have to attach copies of bank statements. You have to close your bank accounts so that the U.S. trustee can follow what you're doing by consolidating it into one account, unless the court authorizes it otherwise. And you have to make sure you're disclosing absolutely everything. And I think the absolute disclosure is what throws most CEOs, because business is often done on a handshake and it's not quite as formalistic as attorneys would like. And so making sure that your client understands that you've got to be open. Bankruptcy lawyers usually call that an open kimono, because you have you're revealing everything, so to speak. And when you have that open kimono, it's an advantage to your client or to my client for two reasons. One is that you're complying with the bankruptcy code, but the other reason, of course, is that your creditors, and that includes the U.S. trustee, who is a hypothetical creditor under the bankruptcy code, has faith and confidence in you. And so when conflicts inevitably come up, or when problems inevitably come up with your case, and you go to the U.S. trustee and you say, okay, this is a problem, I want to have this resolved, they will usually step in and help you rather than fight against you. But when they don't have confidence in the client and in the lawyer who isn't disclosing everything, they think they're hiding things, well, then that's a problem from the very start.
So where do companies underestimate the time and cost or operational demands involved in a Chapter 11, Todd?
Yep, they do. Bankruptcy is not cheap, and which is quite ironic considering, it's a struggling company. But depending on the level of debt, and depending on the size of the business, there are economical ways to file for bankruptcy. Let's say your business has, I would say, $1.5 million to $2 million worth of debt, even less. The bankruptcy code provides for small business bankruptcies, and those cases are over in 90 days, but they're mostly fairly form driven, which means that your plan has pretty much of a shell. I've drafted a number of these plans, and I can use the same kind of shell. Obviously, the words are different because every case is different, and certainly the background is different, and why people file for bankruptcy is different in every case. But the case moves much quicker because the code requires the plan to be filed in 90 days, and it has a lot more permissive structure for you to get a plan confirmed and for you to reemerge from bankruptcy.
What separates businesses that use Chapter 11 effectively from businesses that continue struggling after they file, Todd?
So I think there's two things. Generally speaking, most bankruptcy lawyers understand that when you file for bankruptcy, you need a plan for how you're going to come out, even before you file your bankruptcy petition. And that means that you have a way that you're going to deal with the creditors, how you're going to class those creditors, put those creditors in a particular class, and how you're going to find your requirements to confirm your plan, satisfy your requirements to confirm your plan. If, on the other hand, you don't do that, right, you're going to run into a lot of problems. Now, that's not to say that those plans won't change while you're in bankruptcy, because bankruptcy is very fluid. Things change very quickly. One of my first mentors used to say that bankruptcy is essentially battlefield conditions. You have to really go with the flow. And if you can't do that, you can't practice bankruptcy law. So, but because these smaller businesses or medium-sized businesses are going to be able to file in a more condensed forum and able to emerge from bankruptcy within 90 to 120 days, the reality is that there is less time for controversy. And that is a huge advantage for small businesses.
Oh, good stuff. Todd, my man, it was a pleasure.
Always a pleasure, Evan.
All right. That's it for today's episode of the Distressed Business Playbook. If you'd like to learn more about Todd Duffy and his work with businesses navigating restructuring, bankruptcy, and complex financial challenges, visit teduffylaw.com. Thanks for listening. And don't forget to like, subscribe, share this episode, leave a review so more business owners can find the guidance they need. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.